So the district attorney's office, from what I understand, is screening charges against both parents.
Did you get any inclination?
And that's not at all what Taylor's lawyer said. Today, we are back in Utah in court, and that is going to be very interesting because we are here. If you have not watched Secret Lives of Mormon Wives, don't worry. If you have, I've got you. If you're like, what is this, Dakota Taylor? What is happening? I've got you. And I'm going to do a quick breakdown of what they are in court for today before we fly to Salt Lake City. For those of you who don't know what this case is about, it is a protective order case with allegations of domestic violence. I do not know if they're going to be getting into factual findings today. We might not, but just in case they do, I wanted to give you the heads up on that because that's what the hearing is for. But we have not covered a protective order hearing together in a non-criminal case. This is a civil protective order hearing that was filed by Dakota against Taylor. We're going to go through it. If you saw my podcast episode about The Bachelorette getting canceled, the Bachelorette was supposed to be Taylor Frankie Paul. She is a TikToker. She was involved and exposed a swinging scandal amongst her friend group. And that, it seemed, was what made Hulu go, you know what we need? We need an entire show. Grab cameras, grab everybody, let's do it. And so that is where Secret Lives of Mormon Wives picked up cameras and was like, swinging scandal, let's go. And then production got paused because between Taylor Frankie Paul and her then new boyfriend, Dakota Mortenson, there was a DV incident that resulted in Taylor being arrested, prosecuted, taking a plea deal, and being on probation. She is currently still on probation. She is on essentially a deferred entry, a plea in abeyance, if you will. And that means that if she stays out of trouble, the felony assault does not go on her record. However, if there are additional problems or incidents, then that felony can end up on her record. She has that open criminal probation case that is not done until August 2026. But also, when cameras picked up, Taylor was pregnant with Dakota's child. So they now have a young child in common. Taylor has children from a prior marriage as well. So that prior incident was much discussed running up to The Bachelorette because apparently, or allegedly, when Taylor got back from filming The Bachelorette, there were additional incidents between her and Dakota. And that was all getting shared with TMZ. And then right before The Bachelorette was set to air, I believe that Dakota shared the video of the DV incidents that the subject of the 2023 case with TMZ. I have a whole podcast. I talk about it. She leaves to go film The Bachelorette, films The Bachelorette, gets back from filming, and there are additional instances between her and Dakota. Both of them make allegations against one another. It is that series of events now, March 2026, end of February, beginning of March 2026, that is the subject of the protective order that we are going to see. There are other legal things going on, a lot of them sealed, but there is still custody stuff going on with Taylor and her ex-husband regarding their kids. There is custody stuff going on with Taylor and Dakota regarding their child. There is a protective order that Dakota filed against Taylor and more. So there are allegations back and forth and a protective order. When that temporary protective order was issued, as they get issued on a very low standard, because the goal of a temporary protective order is to stop what's happening and protect the person that needs protection. In Utah, one of the things that is standard on their protective order, and this will vary by jurisdiction, but one of the things on their protective order is that you can click custody and custody can automatically be determined during that temporary protective order. That's what was done here. We saw a lot of headlines about Taylor losing custody. That's a really broad oversimplification. Temporary custody was awarded to Dakota because of the temporary restraining order. It does not permanently change a custody arrangement. It is a temporary custody arrangement. So in that custody arrangement, that will last until the temporary restraining order is resolved, until another arrangement is made, or what have you. So with all of that circumstance, they are in a hearing today regarding the temporary protective order. It has not been heard on the facts of the case. It has been filed. So the TRO was filed, it was granted temporarily, and then hearings were set. Today is one of those hearings.
Any other preliminary matters before we get into the merits on parent time?
Not that I'm aware of.
So when they talk about the merits, they are not deciding the entire universe of whether this temporary protective order becomes a permanent form of a protective order or a longer form of a protective order. They are just trying to determine parenting time because when this initial order was filed and signed, temporary full custody went to Dakota, and they are trying to sort that out now.
As you already outlined today, we're just trying to look at what types of custody modifications can be made to this order before we all meet again on the 30th.
Okay.
I guess we'll be back here on the 30th.
Given the evidence that's been submitted in this case, the allegations and the petition, we would like to see visitation be supervised, and we'd like to see it preferably by a facility. That can act as a go-between between the parties. We do not believe that it would be safe for my client, for the parties to communicate directly with each other about this. It's also my understanding there aren't really any other options at this point either. And based on the evidence that has been submitted here, I think it's appropriate for safety, given that this is a DV case.
Can I ask one question about this? I even before it was filed with the court, I'd been reviewing. I'm also assigned to the domestic matter. Okay. So I did notice that even after the allegations that led to the criminal charges in 2023, they had come to a resolution. They settled their custody case.
Yes, they did.
And I'm gathering this kind of maybe blows that up to a degree, but
wonderful.
How do you...
So my understanding with the custody case is that a resolution was reached and a stipulation was signed.
Never entered.
It was never entered. There still haven't been financial documents submitted, I believe, by the respondent on that case.
Respondent is Taylor Frankie Paul. Petitioner is Dakota. This is a civil restraining order. There is also a custody case that is pending. There is a guardian ad litem attorney present, and the guardian ad litem attorney represents the interest of the child. So instead of either parent advocating for the child, the guardian ad litem is there to advocate for the child. So I imagine we will hear from the lawyer for Dakota, for Taylor, like for the dad, for the mom, and then for the child.
Well, sorry, Mrs. Paul, it hasn't submitted them. And so that's why it hasn't been entered. And so, I think that the very nature of a protective order is right. Like these things could still be negotiated and dealt with in the custody case, and another agreement could be reached. It hasn't technically been entered, but even if it had, it could have been modified. So
let me ask this too: is he alleging that she's ever done anything that was aimed at the children, directly at the children, or it was incidental, her actions towards him, that where the children happened to be present, or one or more child happened to be present?
Your Honor, we're alleging both. That really? In the moments where the respondent is out of control, and in these moments where the parties are fighting and she is completely out of control, both things happen. She is completely reckless in her behavior towards the children. So yes, if they happen to be in the line of fire when she's coming at him, yes, they will get harmed. I'll draw the court's attention actually to our Exhibit 8, in which my client was holding, their young child.
Well, my question is really more where the anger was directed.
Right.
And we believe also that this is a case that as we look.
She is not answering the judge's question because you can see what the judge is signaling. And it's like, counsel, is this directed at the children, or is this directed at your client?
Look deeper and deeper into the evidence, that you'll see that there's a lot of sort of coercive control happening, and that does involve sometimes
That's a bold argument, counsel.
like acting violently around or towards or slamming the doors of the child's room, trying to disrupt and involve the child in the violence in order to get my client to react.
Okay.
We're requesting today that the parties return to the status quo as outlined in their August 2025 settlement agreement in the custody action. There is a little bit of procedural backstory here that's important for the court to take note of, as well as understanding the substance of the allegations against my client. I am concerned, and I think the court should be concerned about the lack of credibility of Mr. Mortenson. The provisions of the temporary protective order that give us heartburn, to put it mildly, would be paragraphs 15 through 17. This is a total suspension of my client's interactions, contact with their 2-year-old son.
I'll add that ex parte order is exactly that. It was made without your client having been given yet the opportunity to be heard. Yeah.
My point in bringing this up, it's obviously not unheard of. We see this in certain cases, and in certain cases it is appropriate. Makes no sense here, and I think it speaks to how vindictive Mr. Mortenson is.
He's not asking for today, at least for suspension of parent time, right? He's asking for supervision.
We
That's
learned
correct.
that. We learned that today. You're correct.
Okay.
Also important to note in this case, Your Honor, that he has not actually asked for supervision in his pleadings, but I'll come back to that in a moment. Mr. Mortenson, as the court pointed out, filed a custody action on June 25th of last year, and that case was settled August 22nd of last year. I think those dates are pretty important because, as the court already indicated, 8 of the 11 exhibits submitted by Mr. Mortenson predate his settlement agreement, which again, I think calls into question, not absolutely, but I think it would call into question the relevance of these exhibits for purposes of custody and supervision.
Where I think it comes into play is that the statute specifically states that the passage of time per se cannot be the only basis for denying the request for a protective order. Certainly, I consider whether there may be ulterior motives, like trying to gain a leg up in a custody dispute, right?
Right.
Yeah.
Nope, I'm with you, Your Honor. Importantly, in the custody case, he didn't ask for supervision there at any stage that I'm aware of. And like I mentioned, they
That was
said
before the February incident.
yeah, but also after 8 of the 11 incidents. And,
All right.
you know, I'm excited to talk about February because I think that is critically important to look at today. So we'll get there in just a moment. This was settled August 22nd. Both had lawyers. Mr. Mortenson was represented by Mr. Hansen. Taylor was represented by our office with Mr. Ficklin running point on the case. And the result of that settlement is Taylor has custody of this child. It's roughly a 70-30 division. It's mathematically.
It was 20 of 28 days over a 4-week schedule for her overnights.
Yeah, there you go. You've read it. You've done your homework. Appreciate that. They've had, obviously, a tumultuous relationship, and there's been a very well-documented history of Dakota trying to re-engage and re-enter and resume the relationship. And one such example took place on February 23rd of this year, early morning hours.
We don't have a report yet, right, on that incident.
No. All I've heard from Draper City is that they do not intend to pursue charges against either party.
So is this all about credibility relating to parent time?
It is,
Okay. Because
ultimately everything we're looking at here is a lot of what we're looking at today relates to his credibility.
I feel like we're getting into the merits of the underlying claim.
And I'm almost off this point. But if we look at Exhibit G, he's telling her, open the door, I'll watch the kids, let me help, open the door. And then he just comes right out and says what he's looking for. This supposed victim of domestic violence is looking for sex, plain and simple. He asks her, do you want to fuck? In the immediate aftermath of her supposedly attacking him, that's what he's looking for. That's what he's physically on her doorstep demanding, as documented by these text messages. So again, Your Honor, I understand we're here with a narrow goal of looking at supervision, but I do think that the court needs to bear in mind the lack of credibility both today as well as at that future hearing.
Well, I guess the one thing I'm concerned about is her volatility, even if he's pushing buttons. Some of the videos suggest that when she finally snaps, there's significance to it. And is that pose a problem for the safety of the children?
Your Honor, you hit it right on the head at the outset of the hearing in asking Ms. Diaz the question of where is the anger directed. Dakota is excellent at escalating and aggravating my client, and when she reacts, it's 100% directed at Dakota. And any exposure the child would have to that.
I'm not saying it's defensible, but you're answering my question, I guess, is what from earlier, right?
Yeah, absolutely. So this is not, my client has she has no risk to these children.
I don't know how you can, that reaction, even where the children are present, in one instance in his arms, I think, right?
You're talking about the May 2025 incident?
Yeah, we're going back, a little ways, yeah.
I want to address this as well as I can for you. What concerns you about that, Your Honor?
Well, I can have concerns about volatility and not reacting in a different way, even if she feels like she's being provoked, when you have a child right there in front of you. And that's my concern there, is that didn't seem to be recognizing that this child was being exposed to that conduct, whereas maybe she could have turned around and walked the other way. I don't know. I wasn't there, of course, but that's one of the concerns that I have from viewing some of the videos.
Yeah, and I'm sure both sides, or at least my client, would prefer to take that one back, right, and redo that one. My comment on May, because I think this will come up, especially when Mr. McDonald speaks, my comment about the May 2025 interaction is it's important to note that's taking place in my client's home, and Dakota started recording only after my client asked multiple times for him to leave. He did not. Even in the video, when the recording starts, she tells him, "Get out of my house, Dakota." What does he do? He does not leave. He plants it right in front of her, and he says, "No, what you're doing is not okay." He's holding the child as his human shield, so to speak, and provoking my client and not getting out of her house. So this idea that...
Well, if that's the case, he got the reaction that he was looking for.
He got the reaction he was looking for.
I'm not making a finding about that, but yeah.
Yeah. The reason I bring this up is Dakota pushes buttons. He's excellent at that. As long as these folks stay apart, which I think is fully stipulated, they need to stay apart. I don't think there's any risk of them coming together again in the aftermath of this. Then there is no risk to the child. Just in conclusion, we would emphasize the child is safe with Taylor. The child thrives with Taylor. We would just ask the court to remember that this is a new request for supervision. It is not in the request for the protective order. There has been enormous passage of time between both the 2023 and 2025 incidents. We just don't think it's appropriate at this point to commit such an invasion in this parent-child relationship based on such old allegations, and including allegations that have, such as the 2025 allegation, that have an explanation as to my client's conduct. Remember, Your Honor, the resources and network that's currently surrounding and helping this family right now. Lots of help from family, therapists to DCFS. There's been a lot of actions that Mr. Mortenson has made that contradict what he's telling the court today. Most importantly, I think, his decision to give my client custody only 6 months ago, after 8 of the 11 incidents in his exhibits took place.
Leonard, is it that time of year where finances are on your mind a little bit? I know, me too. Always happens in April. But here's one of the things that has made my life running Baker Media so much easier, and that was switching to today's sponsor, Gusto. And we switched to Gusto well before they ever reached out to us. And so when Gusto reached out to sponsor, we were like, yes, we love Gusto, because it has made it so easy to take care of all the business things like payroll, taxes, HR. And Gusto makes those things easy. Gusto is an online payroll and benefits software built for small businesses. It's all-in-one, remote-friendly, and incredibly easy to use. So you can pay, hire, onboard, and support your team from anywhere. And we have used Gusto for all of those things. Plus, they have automatic tools and notifications. You know your girl doesn't want to forget anything, so the notifications really help. But also, Gusto has HR experts that can provide you HR support just when you need it, which is a huge peace of mind for a business of any size. And Leonard, you know we've got a deal for you. Try Gusto today at gusto.com/EDB and get 3 months free when you run your first payroll. I know, 3 months free when you run your first payroll at gusto.com/EDB. One last time, head to gusto.com/EDB. Now let's get back into it.
We did make a grammar request to Draper Police Department.
The guardian ad litem is speaking.
We had a response on April 1st. That response was a denial based on the records being with the district attorney's office and the case basically still being open. So the district attorney's office, from what I understand, is screening charges against both parents.
Did you get any inclination?
And that's not at all what Taylor's lawyer said. Well, there is that. Draper Police denied the public records request to the guardian ad litem, who represents the child's interest, not the mother, not the father, just the child. And the file is with the district attorney, who is considering filing charges against both. That is a very different posture than presented by Taylor's attorney.
So I think, Your Honor, in looking at everything, the things that I want to focus on, and I know the 2023 incident is old, and frankly, it involved another child. But I think that it's important in assessing the potential danger to my child, to my client. I think the court touched on volatility, and that's what I see when I watch what's been submitted to the court. So going back to the 2023 incident, and I'll be brief with that. Charges came out of that. The district attorney's office.
The 2023 incident, sorry, that was a rude pause for the commissioner, is the one that has a video that was sold to TMZ that is public, that Taylor Frankie Paul is still on her plea in abeyance probation for.
Filed a probable cause statement. This is directly from the probable cause statement. During the argument, respondent threw heavy metal chairs at petitioner, which put holes in the wall. After throwing 2 chairs, told petitioner to stop throwing the chair. Petitioner was told to stop throwing chairs because her child was next to him on the couch. Respondent then threw a metal chair which struck IP in the head. As I look at that, in my mind, she should have the skills to be able to avoid these situations.
That's a fair
argument.
Then
the May incident happened, May of last year. And what I see when I watch that video, and to be fair, I only have the video, and there's a starting point and there's an ending point, and who knows what happened before and who knows what happened after. But Dakota is holding the child, and that's clear in the video, and she's pushing him and telling him to get out of the house. And she's not just pushing him, she's shoving him, and she's shoving him with force. And at one point, it even appears in the video that he trips and almost falls over while he's holding the child. To me, that makes me very nervous about her ability to control herself and her volatility. I don't understand how you have a situation where you throw a chair at someone, knowing that your child's sitting on the couch, the child immediately starts crying. And this is going back to the 2023 incident. And you continue and continue and continue, and you don't immediately stop and attend to the child. That makes me very nervous. And then it's the same thing with this incident that happened in May. The pushing and shoving starts, the child starts crying immediately, and that doesn't snap her out of it. There are alternatives that could have been done if he wouldn't leave the house. Could have walked away and picked up a phone and called the police, asked for a trespassing charge. That didn't happen. That would have been the appropriate way to handle it. I think that the respondent in this case has a very...
I understand where his concern is, because the concern from the guardian ad litem is that Taylor is on a plea in abeyance probation, which means if something else happens, that felony goes on her record. That is normally a very strong incentive. And during the course of that program, she has had to complete domestic violence classes, parenting classes, therapy, remain sober. I have a lot of questions about that, but the guardian ad litem attorney, this is the attorney for the child, the guardian ad litem attorney is saying, look, she has been through the program that we wanted her to do. She received a low risk assessment. She received the tools that we thought would help. And yet we are back here.
I think that the respondent in this case has a very difficult time with self-control, and I think that it puts my client at risk, and has historically put him at risk.
What about the argument made by Mr. Swinyard that but for the parties interacting with one another, that's where the anger is directed at him, not at the child, even though it may be inappropriate conduct, that if they're not in the same place at the same time, that the triggering elements are not there for her to lash out.
I agree that the anger is directed at him. I don't think that the anger has been directed at the child. That's actually demonstrated, I think, in the child abuse charge that was originally filed. They filed it as a reckless charge, not an intentional charge.
Right.
So I think the anger is directed at him, but I'm not convinced that there won't be anger directed at other people that can result in the children being harmed. That's my concern, is just a lack of total self-control, even having been through all of the treatment for domestic violence and things of that nature. And that really concerns me. So I am asking for supervised visits today.
And that's what's
I think the
probably
court
gonna
can order
happen.
that if the court finds that there's potential harm to the child.
That's what's going to happen.
I think based on what's happened historically, the court can find that.
I'm not making any determination today, one way or the other, about whether the respondent in this case may also be a victim of an abusive partner as well. I mean, that's part of the allegations that are being made. There's mutual allegations at this point. The prior allegations have played themselves out in the criminal court. I don't know at this juncture, hearing what the guardian ad litem indicated about there's not yet been a dismissal of that prior criminal matter. I don't know what may come of that. It may be dependent.
Well, if criminal charges are filed, it's going to violate her plea in abeyance. Even if criminal charges are not filed, it violates her plea in abeyance and could change her situation dramatically, which is why the guardian ad litem was so concerned about it.
And upon what law enforcement intends to do with the current incident, the February incident.
Yep, that's going to matter a lot.
A lot of weight to the input of the guardian ad litem as well. Guardian ad litem is someone who's trained. Well, someone who's trained in forensic interviews of children, but the child is really too young in this case to provide any valuable information. But the guardian ad litem also his only interest is in advocating for the best interest of the child, not getting necessarily a spin from what would be an inherently biased party, meaning mother or father. Not to say that they're not each from their own perspectives being truthful, but simply that there is an inherent bias there as well.
Well, yeah.
And I do share some of I have concerns going both ways, quite frankly. I do have some concerns on the one hand that perhaps there has been some, as I indicated, maybe pushing of buttons to get a reaction. It's certainly been, no one disputes a volatile relationship. As I looked at some of the evidence that was submitted, it seemed like a lot of this was going on when he was coming to her place of residence.
Right.
That could have an impact. But also, regardless, the reactions that, even if he was trying to provoke a response, the reactions that actually occurred, they're very troubling. I mean, the one from 2023, I'm not giving as much weight to because it's removed in time, but it's still indicative of volatile, volatile reactions.
Right.
And the hard part for the court is when it happens in the presence. I mean, it's hard in any event, but especially when there's children present during the incident. That's the most difficult part of all.
And concerning.
The May 2025 incident it occurred while the child was in the arms of the petitioner. And there just doesn't seem to have been any thought put into what the reaction, the effect that this might have upon the child. And that weighs heavily with the court. And so for these reasons, I'm going to recommend, again, this is very limited duration. We'll have more information, but I'm going to recommend supervised parent time for the next 3 weeks and 2 days till we come back on the 30th.
When Dakota Mortenson filed the request for a temporary restraining order, he filed that back on March 19th, 2026, relating to 2 incidents in February, though Frankie Paul's attorney has argued that that was like overnight. So it was really one continuing incident. It just went over the midnight hour into the next day. So it wasn't 2 different instances. It was continuing. That was part of their argument. He filed that March 19th, same day that TMZ had some of the sealed filings from his filings, some had the video from the 2023 incident and more. As a part of that March 19th, 2026 filing, he requested temporary full custody. That changes the custody agreement that Taylor and Dakota had reached in the custody case. Sometimes the commissioner is calling it the domestic case, but in the custody case, they had come to a settlement in their custody arrangement prior to this. So the temporary protective order changed the custody arrangement to give Dakota full custody. The reason they were in court today was to navigate that custody arrangement because it changed the 70-30 custody that they had, where Frankie Paul had 70% custody of their child. Dakota had 30%. The argument from Dakota's attorneys were, we think it should stay this way. We think it should stay with Dakota having 100% custody. However, we're willing to have Taylor have time with her son if it's supervised. Taylor's attorneys were saying, we want to go back to the status quo of the custody agreement. This isn't an issue that Taylor is going to harm the child. The issue is when Taylor and Dakota are together, is what Taylor's attorney was arguing. That when Taylor and Dakota are together, that is the problem. If Taylor and Dakota are not together, then there is not a problem. The problem that the guardian ad litem and the commissioner highlighted is that when Taylor and Dakota are together and the child is present, it does not stop Taylor in escalation or in reaction in a way that could be and has been in the past harmful for the child, which is something that was concerning to the guardian ad litem and the court, that the response to Dakota when the child is present is not mitigated by the fact that the child is present, and that is the court's concern. And so ultimately, the court went with the petitioner's request, that's Dakota's request, that time with Taylor and their son be supervised until the next hearing, which at this point is set for April 30th. However, I suspect that that date might shift a little bit because the attorneys are now indicating, well, Taylor's attorney is now indicating that 3:30 might not be enough time. That's a 90-minute window. And the court's like, look, I want to make sure that my staff is done at 5. After what we saw today, I do not think that they will be done hearing the merits of now 2 temporary protective orders. And if they will try to navigate the merits of that, trying to figure out a little bit more of what happened, not just custody. Today, the attorneys went far afield, more so the attorney for Taylor Frankie Paul, but went far afield to try to litigate the facts underlying the petition, not just talking about who or what the custody arrangement should be for the child. So in trying to navigate that, the court tried to rein the attorneys in, but seeing how much argument there was, I do think they're going to need more than 90 minutes. And the reason I say 2 temporary protective orders is because as of this morning, Taylor Frankie Paul had filed a request for temporary protective order. And I do use protective order, restraining order synonymously. However, in Utah, they are different. So when I use them synonymously, I apologize. I default to California language, but they are civil protective orders. They are not part of any criminal case. So when they were arguing that, Taylor's attorney said, hey, we've also filed a restraining order against Dakota. So we are now asking for mutual restraining orders, it seems. Most interesting to me in all of this is we saw both attorneys arguing, the other side, more so from Taylor's attorney, I think. But then we saw the Guardian ad litem kind of putting a check on Taylor's attorney saying, hey, we have also done a public records request, a grandma request, as it is called in Utah, but we've also done a records request from Draper PD. We were denied. Draper PD indicated that the file is with the district attorney's office. They are determining or considering whether there will be charges for both parties, Dakota and Taylor, and yes, both can be charged. Just broadly and generally, we don't know the facts of those incidents or the overnight incident in February. So we don't know the facts of that. But yes, there can be instances where both parties are charged for domestic violence against each other in the same course of conduct. So the Guardian ad litem indicated that DCFS has concerns about Taylor Frankie Paul going after Dakota when the child is present, and Dakota not removing himself and the child from the situation is how I read between the lines when the Guardian ad litem was saying the concern about the petitioner is the failure to protect. The concern for the respondent, Taylor, is the domestic violence in the presence of a child, which had been one of the charges that was dropped in her criminal case. So DCFS and the Guardian ad litem have concerns about both parties and have indicated that there may be criminal charges for both parties. The attorney Guardian ad litem indicated that one of his big concerns with Taylor Frankie Paul is that there is still an open criminal case that she has a plea in abeyance on, that these subsequent instances should or could, the Guardian ad litem didn't say should, I said should, that could violate her probation in that plea in abeyance, which means that that would then be converted to a felony charge. It would not be reduced and essentially come off of her record. But the bigger concern is that she has gone through the domestic violence programs because of that plea and successfully completed it and had a low risk rating when she completed that. And yet there are now quite a lot of incidents between the two. And of course, the Guardian ad litem is concerned for that. Their concern is the child. So the Guardian ad litem is kind of the grounded voice in the courtroom along with the commissioner because their interest is the child. Here, I think the best answer is that Taylor and Dakota stay away from each other for a substantial amount of time and that they navigate co-parenting with support. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.